So we are here today to discuss the decision in the City of Portland versus FCC case. This directly impacts a lot of issues that our membership sees every day. Pole attachments, shot clocks, and aesthetic issues are often things that are really heavily discussed at the federal level, but really impact the local level. And so we are continually working to kind of build and share understanding between providers, local officials, and and other government officials. Um, and so for those of you who are new to this conversation, we hope to make these issues more accessible and easy to understand. Our work shows why broadband is essential for every American, regardless of zip code. And to that end, regulations implemented by the FCC and Congress should embrace local perspectives as they require local implementations. So local officials should be brought to the table. They should be allowed to help craft these regulations that will meaningfully increase the ease with which providers can deploy. And those policies also should respect the very real concerns that municipalities have about how infrastructure is built, where it's placed, and at what cost it's done. So NCC is committed to working with and on behalf of our members to elevate their voices to ensure that local authority isn't stripped away under the guise of removing barriers to deployment. And we look forward to discussing the Ninth Circuit decision today and hope that participants here walk away with a better understanding of what authority remains at the FCC and kind of what has been handed back to municipalities. And so we appreciate having Mark Del Bianco with us today to walk through his analysis of that decision. And by way of introduction, Mark is a communications lawyer in Montgomery County, Maryland. A substantial part of his practice involves advising clients on business and regulatory issues related to wireless technologies, and particularly on the FCC orders governing the ongoing rollout of broadband wireless facilities. He's represented concerned citizens in the debate over small cell bills at the state and county level in Maryland, and drafted small cell ordinances for towns in the state. He's also advised citizen groups in New York and California on FCC small cell regulations as well. On the business side of things, he represents, among others, a new wireless competitor that builds and operates private networks on business and school campuses, and wireless internet service providers in obtaining the necessary licenses and contracts to serve Indian tribes in underserved rural areas. He has also assisted other clients in obtaining temporary or experimental licenses to provide 5G wireless services in Times Square and at various venues, including Major League Baseball and football stadiums, unfortunately not being put to the best use during COVID. So with that, Mark, welcome. Thank you for being here, and I'll turn it over to you.
Thank you, Ryan. As Ryan said, I have done a lot of work in the wireless area, and I've worked with Next Century Cities for a couple of years now on wireless issues. I see Deb Sosha is on this call. When Deb was here, hi Deb, we worked together on the underlying small cell order, which was actually the subject of the appeal in the City of Portland case. So with that, I'm going to go ahead and just talk briefly about what City of Portland does and what the options are for cities. I probably throughout my talk will use the term cities, but it can mean cities, municipalities, counties, any jurisdictional unit that can regulate small cell placement at a level below the state level. So the City of Portland case was a combined case that brought together appeals that had been filed in, I believe, 4 of the 12 federal circuit courts of appeal, involving not just the small cell order, which is what the focus will be today, but it also had elements of appeals of 2 other FCC orders, the one-touch make-ready order, which probably a lot of the people on this call also are affected by, and the moratorium order, which was an order that forbade localities or cities from imposing any kind of moratorium, either de facto or de jure, on small cell rollouts. The focus today will just be on the small cell order, which is the most important part of the decision for this group. So there were 2 parts to the small cell order. The first part actually set out a series of rules that were not very long, and they concerned the timing for approval of small cell applications to provide small cell facilities in a city, and they limited the flexibility of localities or cities to regulate other aspects of small cell rollouts. The second part of the order was what's called a declaratory ruling, which is sort of an advisory opinion by, in this case, the FCC, but in general, it can be any federal regulatory agency with expertise in a certain area. And so the declaratory ruling in this case had many ways much broader implications, because the first thing that it did was it interpreted two applicable sections of the Communications Act, both of which limited the ability of state or local regulators to take actions or enact ordinances or regulations that could effectively prohibit. And those are the key words in the statutes, both of them. Anything that could effectively prohibit the provision of wireless services can be rejected, or is preempted, I should say, by federal agency action. The declaratory ruling applied or interpreted the term effective prohibition, and it did so in a very broad way. What it essentially said was that any action by a locality that materially inhibited the rollout of a facility or broadband deployment was an effective prohibition. So it was a very, very broad interpretation of effective prohibition. There was some fear, at least initially, that the materially inhibits standard would create such a low bar that any action on the part of a locality that actually raised the costs of rolling out a broadband facilities or small cell facilities would be found to be in violation of the Communications Act. It hasn't turned out that way. It's not likely to turn out that way because of what the Ninth Circuit did in the city of Portland. So anyway, those are the two pieces of the small cell order that the FCC issued in the fall of 2018. They were appealed, they were all consolidated, and in August, the Ninth Circuit issued its opinion in the city of Portland case. What it did, first of all, if you've read news reports, everyone initially viewed this as a major victory for the FCC and a huge loss for cities and local governments. And to some extent, that is true. However, there is one part, and I'll talk about it to a large extent today, because I think that is where there is still a lot of flexibility on the part of local governments. So what the Ninth Circuit did in the city of Portland case, first of all, was it upheld most parts of the small cell order. That part's correct in the news report. It upheld essentially everything in the rules, which was the shorter part. And it particularly confirmed that the FCC could impose new shot clocks, shorter shot clocks. I assume everyone knows what I'm speaking about when I talk about a shot clock, but just in case, I'll briefly address it. Shot clock is the term everybody uses for a deadline created by the FCC for a city to approve or act upon an application for, in this case, small cell facility in the particular city. And the shot clocks are created by the FCC in order to have to basically to force the hand of cities and not allow them to sit on applications and use that as a de facto way of either disapproving an application or instituting a moratorium on the rollout of small cell facilities in their city. The FCC had some shot clocks, they've shortened them, and now it's basically 60 or 90 days depending on various factors. So technically within 60 or 90 days, the FCC believes that a city should be able to act upon an application for a small cell facility. The Ninth Circuit upheld that, but the key thing to keep in mind about the shot clocks and about the actual rule that the Ninth Circuit upheld is that there is no effective mechanism. There's no automatic mechanism to enforce it. If a city doesn't make a decision within the shot clock time, the only option open to the carrier that filed the application is to file with the FCC a request, or to go to federal court and file a case and argue to the court that it was not reasonable for the city not to have acted. But the FCC in the small cell order had considered, small cell proceeding had considered but rejected the idea of making the grant of an application automatic at the end of the shot clock period. They rejected that idea. So the real effect of the shot clocks, even after the Ninth Circuit decision, is that they are kind of they're a bully pulpit that somebody could go and seek to enforce at the FCC or the federal district court, but they don't by themselves bind cities to have it active by a certain date. The second part of the court's decision addressed the declaratory ruling portion of the small cell order. In general, they did affirm the materially inhibit standard. So the way to think of it is that any city ordinance or regulation that imposes material costs and materially inhibits the rollout of small cell facilities could be, not is, but could be an effective prohibition on small cell rollout, which then would be a violation of Section 253 or 332C7 of the Communications Act. But again, it's a standard that the FCC has set out and the Ninth Circuit approved, and it's not a black and white. It depends very much on the specific facts of the case. So it gives guidance, but it doesn't necessarily determine the outcome of a dispute. In the City of Portland case, the Ninth Circuit also upheld the application of the materially inhibit standard to the fees question. In other words, the FCC in the small cell order had created safe harbors, which were not actually fee caps. Again, they were more recommendations that the FCC concluded based upon its review of existing agreements and court decisions. It concluded that at certain levels, the fees for right-of-way usage, for pole usage, for annual fees, so on, that at various levels, those would not be challenged by the carriers, and therefore they believe these would be safe harbor amounts. Again, there's no legal effect of them, and the FCC had in its order recognized that any city was free if it could demonstrate higher costs. It was free to go ahead and charge those costs, and it put them into its ordinances. It did say that the costs had to be based on the actual costs of the city. And the Ninth Circuit upheld, again, that portion of the small cell order. So there are, excuse me, there are safe harbor amounts that the court and the FCC have approved, and that, however, is not a legal binding cap on fees. Each city remains free to charge whatever it can prove its costs are. The one area where the court did not totally affirm what the FCC had done under the materially inhibit standard is with regard to aesthetics, which is, of course, a big issue for many cities, and particularly medium and smaller towns, which have in their view, a characteristic look that they want to make sure is retained. So what the Ninth Circuit did on the aesthetics question was it actually rejected the standard that the FCC had developed. The FCC had said that in the aesthetics area, any requirements imposed by local governments had to be, first, reasonable, second, no more burdensome than those applied to infrastructure deployments by other providers of communication services, and they had to be three, published in advance, and four, objective. Well, the Ninth Circuit, in reviewing what the FCC had done, concluded that to the extent the declaratory ruling required that small cell facilities be treated in the same manner as other types of communication services, it was in error. And the reason was that the governing statute here, section 332C7, permitted localities to treat different communications providers differently, as long as whatever the regulation was, and here I'm quoting, did not unreasonably discriminate among providers of functionally equivalent services, unquote. So the FCC, the Ninth Circuit decided, had effectively ignored that language and broadened the service providers which were used for the basis of comparison. In other words, the Ninth Circuit said that this language of requiring no discrimination among providers of functionally equivalent services only referred to wireless providers, and effectively only to wireless providers that were providing the same service as whatever the application for the facility was for. So the FCC, which had required that there be comparability to other types of communications providers, such as cable providers or wireline telephone providers, had erred and made its discrimination requirement too broad. So what this means is you can go ahead and distinguish between the requirements a city imposes on wireless carriers and impose stricter and more expensive requirements on wireless carriers than on other types of communications carriers. They also held that because the language of the statute permitted discrimination that was not unreasonable, that the FCC had erred in when it required that all aesthetic criteria must also be objective. So basically what the court did in the area of aesthetics was it threw out two of the four requirements the FCC had imposed. So in the wake of the Ninth Circuit decision right now, local aesthetics requirements are acceptable just as long as they are reasonable and no more burdensome than those applied to infrastructure deployments by other providers of functionally equivalent wireless services. They do not have to be set out in advance, and a certain degree of objectivity is permitted. Although obviously, since the Ninth Circuit case only came down last month, there has been no further discussion or testing of what the scope of objectivity is and how that's going to work. So with regard to the case, the bottom line is that right now that case is the law. There are about 2 more weeks left in the period for which the decision can be appealed to the entire Ninth Circuit. What's called an en banc hearing can be requested. I have heard rumors that some of the cities are beyond considering and have actually hired counsel to file it for an en banc appeal. And I've not gotten any confirmation of that, but I do have reason to suspect that there's going to be a request. Now, filing such a request doesn't change the law at all right now, because until the court acts on a request, the panel decision is in effect. If the court denies the request, then the option that the cities or any party to the Ninth Circuit case has is to file a petition for certiorari, that is a request to the Supreme Court that it accept the case on appeal. It's a discretionary appeal, and the Supreme Court, I believe, is unlikely to do that. But that possibility would still be out there for about another 50 days, 55 days, I guess. But I don't know whether that's ever going to happen. So I guess the question for at least for now is, what are the effects of the decision on members of Next Century Cities? I've talked to some extent about that. And maybe, I'm happy to talk about how it might affect various issues. But if anyone has a question about a specific issue before I start going into that, I'm happy to take any questions about what it might mean for your particular issue. And if there aren't any questions, I will talk a little bit about the issues that I believe it affects most clearly and how that effect may play out.
And if anyone does have any questions, if you could just raise your hand and then we'll call on you and we'll go that way.
Lucas, does that raise hand function show up for me, or does that only show up for you? I've never used that on a Zoom call before, so I don't know.
It'll show up for you as well, Mark, but we do have a question in the chat from Rondella. She
Okay.
asked, how does the order affect states with small cell legislation?
Well, that's a good question. It depends to some extent on what the legislation is. For example, states that have legislation that strips localities of most of their power to legislate or to regulate small cell rollouts within their own local jurisdiction, it will have no effect on. I'm thinking of particularly the one I'm familiar with is Florida, which has a very restrictive statute that basically has taken away most local jurisdiction to regulate small cell rollouts. So this case would have no effect on that. If there were a state statute simply said every municipality has the jurisdiction to do X, Y, or Z with regard to regulation of small cell rollouts or small cell facilities, again, there wouldn't be any effect of this case on that type of legislation. Where there might be some effect on the state legislation, I guess, would be to the extent that the state legislation exercises certain functions that are in most states covered by the locality's jurisdiction. Just to give an example, if a state had a statute that said all small cell rollouts antennas have to be painted blue, then obviously that would be affected by the standard here, because the two statutes that I mentioned, the two statutory provisions that I mentioned, Section 253 and Section 332, they apply across the board, not just to states and localities and counties, but also to cities, localities, and counties. They also apply to states. So this would apply to states, but I am not familiar with a lot of states that have legislated in ways that would necessarily be effective. So I hope that answers the question. Without knowing, if somebody had a particular state law in mind and could identify specific provisions, we could talk about whether this might affect them. Okay.
We do have another question in chat from Maureen.
Sure.
She asks if you can repeat what you mentioned about the Ninth Circuit decision on aesthetics. They must be reasonable and no more burdensome than applied to what?
Oh, then applied to infrastructure deployments by providers of, and here's the key phrase, functionally equivalent wireless services. So if you're providing a broadband service, broadband wireless service, that's probably the functionally equivalent wireless service against which your discrimination and reasonableness would be measured. It might not, it's not clear, but it might not be just a voice provider of 2G or 3G services. So there may be some room for discrimination even between voice services and other broadband wireless services. But that's, again, an open question nobody has dealt with or considered at this point. The last segue, or last question is a good segue, because most of the rest of what I'm going to be talking about is in fact related to aesthetics, because that is the one area where the small cell order and the Ninth Circuit opinion in the city of Portland have combined to leave a fair amount of discretion in the hands of local regulators. So the first thing, I guess, is I would recommend that each city or local jurisdiction take a look at their situation. Look at whether you have an existing regulation, whether you are likely to have requests for small cell rollouts, whether you have existing requests for small cell rollouts, whether you have small cell facilities already, but you're expecting more. And think about how you can prepare for the future. You may want to, if you have a regulation in place, you may want to revisit it in light of the restrictions that okayed by, or excuse me, the local powers that were confirmed by the Ninth Circuit in the city of Portland case. And if you don't have a regulation in place, you may want to draft one and get it in place so that when the time comes that you start getting a raft of applications for 4G. I won't call it 5G. I'm trying to use small cell as the term because even though people often conflate the two, there really are very few 5G rollouts going on, true 5G rollouts going on across the country. Most of what's going on in terms of small cell rollouts is they are putting out 4G services, putting the antennas and facilities, excuse me, much closer together so that they will be prepared for 5G and also so that they can use the 4G broadband and provide it to a much wider swath of areas. So, assuming that you're going to be looking at and you're either an existing regulation or drafting some kind of a new regulation regarding small cell deployments, there are a number of key issues that I have found my clients, whether they are on the commercial side or whether they're on the concerned citizen side or whether they are the cities or municipalities themselves, tend to focus on. And there's nothing, what I'm going to do is address several of these issues and talk about what is now permissible in light of the decision in the city of Portland and how you may want to be thinking about it. So the one issue is minimum spacing. That is, if I've seen a number of jurisdictions that have decreed that there must be a minimum space between small cell facilities so that there's just not small cell facilities everywhere. Minimum spacing is, according to the FCC, a subset of aesthetics. Therefore, it's governed by the same standard, and the court didn't address minimum spacing. So what that means is you can have a provision that requires minimum spacing. But if you're going to do that, you have to keep in mind that the minimum spacing has to be measured only between the antennas or facilities of the particular carrier that is applying for a new facility. In other words, let's say you have created a 500-foot minimum spacing or 1,000-foot minimum spacing. You cannot deny an application for Verizon because its location is within 500 or 1,000 feet, whatever your limit is, of an AT&T or a T-Mobile facility. Because if you were to do that, then whoever the first mover that came into your city could essentially make it impossible or very difficult for others to get coverage when they came into the city. And that would be an unfair discrimination between functionally equivalent wireless providers. So you can do a minimum spacing, you just have to measure it against the facilities of that particular carrier and not any carrier in your city. Now, something to keep in mind here as you think about this is there have been no cases and no FCC decisions about what minimum spacing applies. And the acceptable minimum spacing is going to be largely a function of how far apart they can reasonably be and get coverage. So this is an area that's going to be fought about because right now, I don't think there's any technical agreement on how far a particular antenna type can send its signal and broadcast or communicate in a way that effectively provides the service. So my guess is whatever number, and most of the numbers I've seen are between 500 and 1,000 feet, whatever number is picked, there probably will be some fights somewhere over it. So just keep that in mind.
We do have a question in chat regarding spacing.
Yep.
So as you noted, the decision notes that municipalities can't limit antenna placement or spacing requirements between different carriers' facilities. But it also notes that the municipalities can restrict the placement of antennas as long as there are reasonable alternatives to the placement sought. The question
Yes.
asks, can a municipality require providers to place antennas on existing facilities if available rather than putting them up on their own poles?
Yes, and this actually ties in with another issue that I was going to talk about, which is co-location. A municipality can create a list of preferred locations. You can the list of tiering, I've generally referred to it as, it can be both within the rights of way, and it can be a combination of inside the right of way and outside the right of way. So your tiering could be preference for the right of way first, preference for existing buildings outside the right of way second, third preference, new structures outside on private property or otherwise outside the right of way. And then within each of those three tiers, you could have again, a tiering system, so to speak. So within the right of, let's just take the first group that I mentioned there, the right of way. Within the right of way, you could say our first preference is existing telephone poles or utility poles owned by the city and over 35 feet. Second preference is privately owned utility poles over 35 feet. Third preference is city-owned light poles. Fourth preference is anything else is within the right of way. So yes, you can make that up, and in fact, in advising both groups and municipalities, these discussions are becoming more frequent. And a lot of group municipalities, cities are looking at exactly that because it does give them a lot more control. It also makes it a more complex process because if you really have to have an idea of what alternatives are out there, and you may have to craft your ordinance that to require in the application process that the applicant show what the alternatives it considered and rejected are, or show why it particularly selected this location. So yes, the answer is you can do that. It just does complicate the application process, which you have to think about both in terms of how much work there will be for your staff. And a lot of the smaller cities and towns don't have any real dedicated staff to consider small cell applications. And there's also a related issue, which is co-location. And that is, you have to think about whether you want to have 2 or 3 of these antennas on the same pole and sort of concentrate the ugliness, or whether you want to not have that because it's unfair to require it because that imposes the visual harm on just a few nearby houses, whereas, or homeowners or residents, whatever. Whereas if you don't require co-location and spread out the antennas, the visual blight is shared among more of your residents, as it were. Related also to this is that I wanted to talk about briefly is the gap in coverage issue. There have been so far a lot of different standards adopted by courts of appeal across the country about when and how a city can deny an application for a new cell tower and whether the applicant has to show a gap in coverage. My right now there are several circuit courts and that have required a showing or allowed a town to require a showing of a gap in coverage before approving a new cell tower. Most of those, all of those cases apply to the really large, the 150-foot, 100-foot cell towers. There haven't to date been any decisions regarding gap in coverage application to small cell wireless facilities. And my view is that after this Ninth Circuit decision, the materially inhibit standard, which was an alternative to the gap in coverage standard for placement of antennas only, not for everything else, that will become the standard in all, because it's been adopted nationally by the FCC and the Ninth Circuit, even though the Ninth Circuit's jurisdiction technically only applies to a few states out west. These cases were all consolidated, so the Ninth Circuit's decision, in theory, applies to at least the cases from various other circuit courts that were consolidated, and therefore theoretically applies in those circuit courts also. But it's a confirmation of what the FCC had done on aesthetics and material inhibition and location. So I'm pretty sure that in the coming years, it will be, or even months, it will be adopted by all the other circuits. So the gap in coverage standard for denying an application for a small cell facility, I think is really not going to be a viable option anymore. And if I were a city that had a gap in coverage standard, or if I were in the Fourth Circuit or one of the other circuits which applies so far a gap in coverage standard, I would assume that's not any longer going to be good law. Undergrounding is not, go ahead.
Yeah, if I could just kind of follow up on that a little bit, is that specifically on wireless broadband service, or is that related to 3G, 4G voice as well?
Oh, it's all wireless services. I would, but the fact is that there's not, at this point, there's not going to be a whole lot of distinction between 3G, 4G voice and 3 and 4G broadband in terms of where the antennas are placed, because they are for 3G and 4G voice in urban areas, which is really where you're going to get small cells for now. You're not going to get small cells far out in the suburbs. You'll get them in close-in suburbs, but you're not going to get small cells out in far out suburbs. And you're certainly not going to get them in rural areas. You might get them in towns of 50 or 100,000 in rural states, but realistically, small cells are never going to be a good option for areas that are not fairly concentrated in size, because you just have to put too many of them out there and it's just too expensive. So I'll talk about undergrounding because a lot of cities and suburban areas do require undergrounding. And again, it's a subset of aesthetics. It's covered by the same standard under the Ninth Circuit and the FCC decisions. So what that means is right now, you can apply for, you can require for wireless service everything to be underground except obviously the antenna. Although I've heard rumors that they're trying to figure out ways to have antennas basically at street level with some sort of radio frequency permeable cover over them that would allow them to work essentially at ground level rather than be mounted on poles. I'm not holding my breath for that. But everything else you could require to be put underground if you require all other wireless carriers to put their equipment underground. And this is actually one of those areas where the Ninth Circuit decision does make a big difference, because could make a big difference. What the FCC had done was said, you can't require undergrounding unless you require undergrounding for the similar facilities of every communications company. And what the Ninth Circuit said was, no, the comparable group to determine whether you're unreasonably discriminating is not all communications companies. It's only the competing wireless carriers. So you could potentially have an undergrounding requirement that is different for wireless carriers than all of your other utilities in your town. One issue also that I've had a couple of questions, not from this group, but from clients and others, is about agreements that can be negotiated for rollouts between infrastructure providers, whether a carrier itself or somebody like Mobility or Crown Castle that's just putting up infrastructure on behalf of the carriers. Whether you can go ahead and negotiate an agreement with the infrastructure provider or the carrier that differs from what the FCC rules are. And the answer there is—
Forgive me, Mark, for interrupting you, but I do want to point out that Stacy Pies from Crown Castle is actually on the call, so I want to make sure that I put that out in the universe in case that's helpful.
Oh, hi, Stacy. I haven't seen you in a long time.
Hi, Mark. Thanks, Marcella. No, I don't feel like I'm spying here. I thought I could.
Okay. Well, I'm not going to say anything bad
You can.
or anything worse than I would.
You can have your opinion. You're very much
okay.
entitled to them. Thank you.
So the answer is that you can negotiate agreements if you want to with either carriers or infrastructure providers. And when I finish this answer, now that I know that Stacy is here, I'm going to put her on the spot for a second and ask her a question. So you can go ahead and negotiate. However, the small cell order and a couple of other orders that the FCC has issued around the attempt to speed up broadband deployment has given the carriers all the leverage and basically removed a lot of their incentive to engage in any kind of negotiations anymore. So what I have heard from clients and what I have intuited is that there's very little negotiation of agreements going on as compared to 2 or 3 years ago. And it's not likely to go on in the future, except in certain very desirable urban areas, or perhaps some larger college towns, which are desirable for their characteristics, their demographics. And therefore, it's unlikely that we're going to see a raft of new agreements like we saw 2 or 3 years ago. And Stacy, I'm just curious if Crown Castle is, I won't ask you to compare it to what you were doing, but are you still pursuing agreements with particular cities? And if so, without naming any of them, are there demographics that are interesting to you?
Mark, thanks. That's an interesting question. We absolutely are still pursuing agreements, and there hasn't been enough time since the Ninth Circuit decision for us to see a real change in how those negotiations are rolling out. But we're in constant contact in cities all around the country. As you probably know, we build on behalf of our carrier customers. So we are negotiating agreements in those cities where our carrier customers intend to deploy. So that is not something that we determined, but our customers determine. But we're still on track. Everything still looks very similar to what it did a month ago or 2 years ago. There are a lot of issues that come up in these negotiations that I don't know if I would describe it as falling outside of the FCC's orders, but issues very specific to particular jurisdictions and what those jurisdictions are attempting to accomplish when they are negotiating with Crown or with carriers. You know, I don't have to tell you all, but every city has different needs. And we work very hard to try and meet the needs of those jurisdictions. And those are often incorporated into our negotiations and ultimate agreements. I don't know if that answers your question. It was a pretty vague response. But.
Well, but I think it might be useful for people on the on the Zoom. If I can ask a follow-up call, just to what extent are you negotiating agreements in cities that don't have, and I apologize, but this, I think it would be useful information. Are you negotiating or are you negotiating on behalf of your clients or your carriers with cities that already have small cell regulations, and you're negotiating agreements that are different from those regulations? And to what extent are you negotiating with cities that don't have regulations, and therefore the agreement is an alternative, at least for your company and its clients, to regulation?
Mark, I don't know that I have an exact answer to that question. I would have to check with our local teams. I think it's a real mix. You know, there are cities, as you pointed out, where we do have agreements in place and we file our applications and they're processed and we deploy. So there's less to negotiate. But there, as I said, there's still issues outstanding that may not be addressed by the FCC's orders. And in that case, we're required to negotiate so that we can get our permits and move forward with deployment. Okay. So it you know, I don't have numbers, but it's a real mix.
Okay, Francella, I'm covered most of what I intended to cover. I'm happy to answer more questions. And I do want to thank Stacy, because that was actually very helpful, I think.
And I also wanted to thank Stacy, because I really just wanted to shout her out because I saw her picture on the list. So anyway, thank you, Stacy.
I didn't think I could hide my picture, but it's really helpful, and I appreciate being invited and being welcomed on the call, because it's helpful for us as an infrastructure company to know and to understand. We know the basic concerns because we hear them all the time, but it's helpful for us to know and understand what's still lingering, precisely because we do engage with the local jurisdictions every single day, and having that information helps us be better partners. We know you want the broadband, and we want to be able to deploy it.
Yeah. Well, thank you for your efforts. Ryan?
I guess we have a few minutes left. This will be a last call. If anyone from any of the localities has a question, please either raise your hand or drop it in the chat, and we'll be happy to ask that. A few seconds for that.
And if we don't have any questions from local officials while you guys are thinking, I did want to ask Mark, just in your final thoughts, are there issues where you want to see local officials show up in terms of actually saying what they're concerned about, whether it be at federal or state policy, like how this fits into the larger picture about local authority, and just making sure that local governments have the options to create, you know, their own future?
I don't have any in mind particularly, but I would point out that this small cell order was issued in an FCC proceeding that has been ongoing for several years now and will be ongoing into the future. And the FCC has asked for comments on various things before. They're going to do it again. And it all relates to accelerating broadband deployment across the country. And what they have done to date, largely, particularly in the last couple of years, has largely involved taking away the locality's ability to control the rollout of large numbers of facilities in their jurisdiction. That trend is going to continue, as far as I can tell, unless there is a concerted effort on the part of states, localities, counties to demonstrate to the FCC that they can manage the rollout on their own in a way that benefits their locality, but also preserves the core values that they think are important to their community. And that is going to have to be both conveyed to the FCC going forward. And as everyone knows, there are going to be changes at the FCC, even if the Trump administration continues, because they've just nominated another person to replace Commissioner O'Reilly, and there are likely to be other changes. So I would say just, work with groups like Next Century Cities, figure out where you can have some kind of an impact on the interplay of federalism, the maintaining of the power of local governments to regulate what happens in their city and what goes up on their polls. And you can do that at the federal level through a group like Next Century Cities. You can do that by testifying. You can do that by enacting reasonable regulations, because to the extent that there is reasonable regulation at the local level, it really undercuts any argument that further deregulation and denuding of the power of localities is necessary at the federal level. You can take away, by your own actions at the local level, you can take away some of the arguments that are being made for action at the federal level that hurt you.
Well, we thank you. We're almost out of time. I want to make sure that Ryan gets to close us out, but to the local officials that joined us today, we're here for you and hope to continue to be a resource.
And much to that. So thank you, Mark, for being here. Thank you for your wonderful summary of the decision. And thank you everyone for attending. If there are any kind of questions that come to you after you get off this call, if something pops into your mind, please feel free to reach out to me or any member of our team, and we'll certainly try to get that answered for you. But again, thank you all for being here. And since I don't want to keep anybody too far past the top of the hour, thank you again. And we look forward to doing this again, hopefully with another just as interesting topic.
Thank you,
everyone.